सर ये जो है सर,
So very good evening all
ये
the
जो है सर।
participants. Today we will be discussing the case laws which are applicable for this current syllabus, which is applicable up to 30th of September 2026. So from 1st October, syllabus is changing and they have added 18 new case laws. So you are lucky that you are required to read only 72. The next batch will read 90 case laws instead of 72. So Varun Ramanji, please explain this case law, NCLT in the matter of Aircel Limited. Can you explain?
हाँ सर, यस सर।
Yes.
सो ये क्या हुआ सर, एनसीएलटी, आई मीन लाइक एयरटेल हैड गॉन इनटू एनसीएलटी, आई मीन एनसीएलटी on insolvency, and they were not paying the installments of the spectrum licenses.
Hmm.
So the Department of Telecommunication were, threatening to, cancel the licenses,
Hmm.
and therefore the resolution professional had approached the NCLT
Hmm.
seeking a restraining order of the NCLT to not cancel the spectrum.
Yeah.
What to say, the defense of the resolution professional was that the
Hmm.
spectrum licenses are necessary for the entity to continue as a going concern, and that will have an impact on the resolution process.
Right.
So the question was, like whether this can be considered as a, whether this can be, I mean, such restraining order can be passed. So considering this to be an essential services, and whether DOT can be restrained from restrained from not terminating the resolution process.
Hmm.
So NCLT had examined the matter and said that the continuation of the spectrum licenses is necessary for the purpose of um, uh, continuing of the entity as a going concern, and
Hmm.
therefore they said that it has to, they cannot terminate, the DOT cannot terminate and pass the restraining order.
Okay. Very good.
Yeah.
So now everybody is clear about this case law. काजल किरण जी, आपको मालूम ही है क्या है केस लॉ?
Yes, sir.
So now can we attempt these questions? फर्स्ट क्वेश्चन पढ़िए, क्या है? एक मिनट, इसको ना मैं दूसरा शेयर करता हूँ। मेरे को लगता है कि जस्ट इसमें आंसर साथ में आ रहे हैं। जस्ट अ मिनट। हाँ, इसमें मेरे ख्याल से क्वेश्चन अलग आएंगे आपके पास। जस्ट अ मिनट। ये हाई कोर्ट आ गया। यस, नाउ इट इज ओके, क्योंकि इसमें क्या है, आंसर साथ में नजर नहीं आ रहा। पहले वाले में ना आंसर भी सब नजर में आ रहा था। ओके, तो लेट मी शेयर दिस फाइल विद यू। अदरवाइज क्वेश्चन पूछूंगा साथ ही में आंसर नजर आ जाएगा तो फिर फायदा नहीं। यस, तो नाउ आई थिंक इट इज विजिबल। यस, विजिबल है ना आपकी स्क्रीन पर?
Yes, sir.
हाँ, तो अब इसमें क्वेश्चंस देखते हैं, ठीक है। क्वेश्चन ये है कि इन एयरसेल लिमिटेड एनसीएलटी मुंबई टेलीकॉम लाइसेंसेस एंड स्पेक्ट्रम ड्यूरिंग मॉरिटोरियम वर हेल्ड टू बी, क्या था आंसर इसका? क्या होना चाहिए? आप केस लॉ आपने समझ लिया, सो नाउ व्हाट शुड बी द आंसर?
C, essential goods or services. Their cancellation during moratorium would destroy going concern value.
हाँ, तो बी होना चाहिए आंसर इसका,
Yes, sir.
है ना?
C, sir. C, sir.
B. B है essential service वाला काजल।
अच्छा B वो आगे चला गया था सर, तो C देख लिया था मैंने। B है सर, यस।
नहीं, ये जो सामने आपको नजर आ रहा है यहां से पढ़िए अब आप। ये काजल किरण जी क्वेश्चन नंबर 531 ये आपको नजर आ रहा है ना?
531 सर, 531।
हाँ,
ओके सर। इन
नहीं
एयरसेल
ये
लिमिटेड
स्क्रीन नजर
एनसीएलटी
आ रही है आपको या नहीं?
सर आ रही है नजर,
हाँ, तो इसमें आंसर क्या होना चाहिए?
आ रही है नजर सर।
क्या होना चाहिए आंसर?
सर बी।
हाँ, बी होना चाहिए, ठीक है।
बी
नाउ
सर,
नेक्स्ट।
एसेंशियल सर्विसेज और एसेट्स।
हाँ, ठीक है, समझ में आएगी आपको। नेक्स्ट क्वेश्चन देखते हैं। इन एयरसेल लिमिटेड एनसीएलटी हेल्ड द टेलीकॉम लाइसेंसेज एंड स्पेक्ट्रम कम अंडर।
Sir, C.
गवर्नमेंट
essential
प्रॉपर्टी
goods or
एक्सक्लूडेड।
आंसर कौन सा होगा?
Sir, C
सर
होगा
एसेंशियल गुड्स और
essential goods or
सर्विसेज, देयर कैंसिलेशन ड्यूरिंग मोरेटोरियम वुड डिस्ट्रॉय गोइंग कंसर्न
हाँ,
वैल्यू। सी
बिल्कुल
होगा,
बिल्कुल,
सी
सी ही
होगा
होना
सर।
चाहिए, राइट।
यस सर।
नेक्स्ट केस लॉ देखते हैं। इन द मैटर ऑफ जेट एयरवेज लिमिटेड, ठीक है, तो जेट एयरवेज लिमिटेड का केस क्या था? अमरिंदर कौर जी, कैन यू एक्सप्लेन? आपने पढ़ा ये वाला केस, क्या है ये? और नहीं भी
नहीं,
पढ़ा तो यहां से पढ़ सकते हो आप।
तो पढ़ा नहीं है बट अभी पढ़ सकती हूँ।
आप पढ़ लीजिए प्लीज। हाँ,
हाँ।
इसमें पूरा नहीं पढ़ना आपको, यहां से देख के, आपको यहां से देख करके एक्सप्लेन करना है क्या इसमें फंडा क्या है।
Okay, sale of
हाँ,
non-core assets during CIRP for value maximization, cross-border insolvency coordination, production and interest rate reduce.
बस फैक्ट से पढ़ लीजिए, फैक्ट्स पढ़ लीजिए।
During the CIRP of JTLB, the corporate reserve provision applied for
नहीं, आप
approval.
पढ़ लीजिए, यू कैन रीड अलाउड।
अच्छा,
हाँ, सभी के लिए
during the
पढ़ लीजिए। हाँ,
factor during the CIRP of Jet Airways, the corporate debtor, the resolution professional applied for approval to sell one of the non-core encumbered asset floor of a building at BKC Mumbai, encumbered to HDFC so as to maximize the value of the corporate debtor. Simultaneously, insolvency proceeding had been initiated against Jet Airways in the Netherlands, raising cross-border complicities. The COC had approved the arrangement and employee association sought their dues, including provident fund and gratuity.
so now here the issue is whether you can sell encumbered assets, because these assets were encumbered. So this is the issue. Here they were encumbered to HDFC and still RP sold. RP applied for approval to sell one of the non-core encumbered assets, because you know that during CIRP you cannot sell encumbered assets.
Yes, sir.
But in this case, RP said that okay, I want to sell one of the non-core encumbered assets. So he is saying that I am not selling the core assets, I am selling the non-core assets. This was the issue. ठीक है, तो क्वेश्चन क्या है इसमें? whether the non-core assets of the corporate debtor over which a security interest already existed in favor of HDFC could be sold during the CIRP, ये क्वेश्चन था इसमें। तो इसमें रीजनिंग क्या दिया इन्होंने? NCLT permitted the sale of the non-core encumbered asset during the CIRP for value maximum, because sometimes the courts allow something what is not written in the code to basically retain the core value of IBC. Preamble में क्या लिखा है? Maximization of the interest of all the stakeholders. तो इन्होंने अलाउ कर दिया सेल ऑफ नॉन एनकम्बर्ड एसेट्स, नॉन कोर एनकम्बर्ड एसेट्स फॉर वैल्यू मैक्सिमाइजेशन. So the applicant was permitted to sell the premises and use the proceeds to settle HDFC's claim. अब वो एसेट्स बेच करके HDFC का भी क्लेम सेटल कर दिया, with HDFC giving up its security interest and charge over the premises against receipt of that sum. and with the balance applied towards settlement with US Exim and CIRP cost. तो उनका कोई Exim बैंक का भी लोन था और CIRP cost they were also met. So this arrangement approved by the COC on 24th April 2020 was sanctioned because it produced substantial value addition for the corporate data. Employees' dues were directed to be taken care of. ठीक है. इसमें क्रॉस बॉर्डर इंसॉल्वेंसी का इशू था. क्रॉस बॉर्डर इंसॉल्वेंसी में होता क्या है, जो एयरलाइंस होती हैं इनके बहुत सारे एसेट्स फॉरेन कंट्री में भी होते हैं या वहां पर भी इंसॉल्वेंसी प्रोसीडिंग शुरू हो गई, तो वहां जो एयरक्राफ्ट खड़े वो बोल रहे हैं भाई हम तो यहां से जाने नहीं देंगे. ये इशू था इसमें. तो ऑन क्रॉस बॉर्डर एस्पेक्ट द प्रोसीडिंग्स इन द नीदरलैंड्स वर कोऑर्डिनेटेड and the resolution plan later submitted by Jalan Fix Consortium was addressed with the process. Statutory dues such as provident fund and gratuity were directed to be honored in full, a position affirmed in the connected jet aircraft maintenance engineers proceedings. ठीक है. So the sale of non-core assets and the settlement with the secured creditor were thus approved as a value maximization step during the CIRP. अब ये क्वेश्चन देखिए जरा. In Jet Airways NCLT Mumbai, non-core assets of the corporate debtor with existing security interest in favor of HDFC. ये क्वेश्चन नजर आ रहा होगा आपको. हाँ, ये वर्डिंग शायद प्रॉपर नहीं भी हो सकती, बट कुछ इस टाइप की वर्डिंग दे सकता है, तो द आंसर हियर विल बी डी. ठीक है. नेक्स्ट देखिए. In Jet Airways NCLT Mumbai, the cross-border insolvency aspect arose because ये क्रॉस बॉर्डर क्यों इशू अराइज हुआ इसमें?
जी सर, नेदरलैंड्स का भी इंसॉल्वेंसी प्रोसीडिंग्स
because simultaneously insolvency proceedings were initiated against Jet Airways in the Netherlands.
Yes, sir.
In the matter of Videocon Industries, तो इसमें इशू क्या है? This deals with the doctrine of substantial consolidation. Because as you know, normally क्या होता है कि each company is a separate entity. But here, because lot of companies were there, जैसे वीडियोकॉन ग्रुप में क्या था भाई, एक कंपनी बना रही है पिक्चर ट्यूब, दूसरी बना रही है स्क्रीन, इस तरह से अलग अलग, और आपस में ही वो सप्लाई कर रहे होते थे. समझ रहे हो? एक का जो फिनिश प्रोडक्ट है वो दूसरे का रॉ मटेरियल है, इस तरह से. अब ऐसे में अगर इंसॉल्वेंसी शुरू हो जाए तो उसको कैसे करना है, तो इन्होंने कहा भाई आप ये ग्रुप इंसॉल्वेंसी की कॉन्सेप्ट लाए इसके अंदर पहली बार इन द मैटर ऑफ वीडियोकॉन इंडस्ट्रीज. एमवीएस कुमार जी, आर यू देयर? एमवीएस कुमार नहीं है. अच्छा चलो, तो वरुण रमन जी प्लीज एक्सप्लेन दिस केस. व्हाट इज दिस केस?
सर, ये जो हुआ था वीडियोकॉन का पूरा सारे के सारे ग्रुप इंसॉल्वेंसी में फंस गए थे. So and there were several loans where like each group were entangled with a lot of loans between the entities, group entities, and and I mean where they owed money to the financial institutions. So because of yes sir, please sir.
This deals with the doctrine of substantial consolidation. As I said, there were various group companies. So the finished product of one company was a raw material for another company. So now here the question, and there were loans also, right? So they said that let us pool the assets and liabilities of related group entities for a unified resolution applied for the first time in India, group insolvency, right? So State Bank of India, it was the lead bank of a consortium. It filed a Section 7 application against Videocon Industries, which was, as you know, engaged in consumer electronics and home appliances. Okay. Now, because the operations and financial entanglements were there among the Videocon group companies, So question arose whether their insolvency processes should be consolidated and their assets and liabilities pooled for a single unified resolution. So this was the issue, right? So whether these could be consolidated so that we can pool their assets and liabilities. So because the operations and financial entanglements were there, so NCLT ordered the consolidation of the CIRP for 13 group entities, including Videocon Industries Limited. So this was the first application of the doctrine of substantial consolidation in India. Right? Now, what is substantial consolidation? It allows the pooling of the assets and liabilities of related entities so that they are treated as a single pool for the purpose of a unified resolution process rather than being resolved separately. So NCLT applied the doctrine where the affairs and finances of the group entities were so intertwined that separate resolution would be impracticable and value destructive. Okay? So consolidation was directed subject to safeguards so as to achieve a coherent value maximizing resolution of the interlinked group rather than fragmented outcomes. Okay? Now the question. The doctrine of substantial consolidation in India was first applied in, although it's very simple question.
वीडियो
but
कौन सर हाँ वीडियो
yes,
पढ़े
यहाँ तो सिंपल लग रहा है लेकिन वहां पर आपको क्योंकि ये केस तो सामने होगा नहीं इस तरह से, है ना?
यस सर
In Videocon Industries, the resolution plan by Twin Star Technologies offered approximately what recovery for financial creditors? कितना वैल्यू मिला था? ये वाला मैंने फाइल शेयर किया है आपसे या आंसर जिसमें है वो वाला शेयर किया है? काजल किरण जी, एनी आइडिया?
सर इसको नहीं शेयर किया सर।
नहीं, अभी शेयर कर देता हूँ, मेरे हिसाब से शेयर किया होगा। एक
पीपीटी तो आया है हाँ।
नहीं, ये वाली तो शेयर किया है मैंने फाइल। वरुण रमन जी बोल रहे हैं शेयर किया। वरुण रमन जी,
वर्ड डॉक्यूमेंट तो शेयर किया
यस
सर
सर
ग्रुप में
किया है
आज,
सर।
कल सुबह शेयर किए थे सर आप।
अब तो अभी आप दोबारा शेयर कर दीजिए इसको, आप कर दीजिए दोबारा इसी को।
मैं एक बार करूंगा सर, अभी करूंगा,
हाँ
ग्रुप में
हाँ,
करूंगा। कर दिया सर,
कर दिया।
ग्रुप में कर दिया सर अभी।
हाँ हाँ हाँ, तो यही सेम ही है ना या कुछ अलग है? जो मैं जिस फाइल से मैं पढ़ा रहा हूँ यही फाइल है, सेम है या कुछ अलग है?
एक मिनट
सर
सर,
सेम है
सेम है सर।
देख
सेम है
लीजिए।
ना? बस, तो इसका आंसर देखिए क्या है 536 का।
सी
लास्ट में आंसर दिया हुआ है, लास्ट शीट में
अबाउट
आंसर दिए
4
हुए हैं।
सर अबाउट 4% ऑफ
536
आउटस्टैंडिंग
का
इज
सी सर, 4% ऑफ द
हाँ
आउटस्टैंडिंग।
हाँ, तो ये इन वीडियोकॉन इंडस्ट्रीज द डॉक्ट्रिन ऑफ सब्सटेंशियल कंसोलिडेशन अलाउड, इसका क्या आंसर होगा?
सी अगेन सर,
हाँ ठीक,
पूलिंग ऑफ असेट्स।
हाँ। अब ये नेक्स्ट केस देखिए, जेपी इंफ्राटेक। इसमें इशू क्या था? So it deals with approval of a resolution plan over the objections of a dissenting
Dissenting
financial creditor and concerns of an operational or statutory creditor, equitable treatment of creditors, compliance with section 30 subsection 2. So this was the issue. इसमें हुआ क्या? In the CIRP of JP Infratech Limited, the resolution plan of Suraksha Realty was approved. ठीक है? ICICI Bank was a dissenting financial creditor. As you know, what is the concept of dissenting financial creditor? Who is
who
a
did
dissenting financial
not
creditor?
vote for the resolution plan,
Ah, yes.
who
Who
did not
votes?
vote for the resolution plan.
Yes, who votes against the resolution plan? Dissenting financial creditor filed an application challenging the plan on ground of unfair treatment compared to other creditors. Separately, Yamuna Expressway Industrial Development Authority raised concerns about land allocations and dues. So, here the issue was whether the resolution plan of Suraksha Realty should be approved despite the objections of a dissenting financial creditor and the concerns raised by Yamuna Expressway Industrial Development Authority. So NCLT dismissed the ICICI Bank's objection, holding that the plan met the requirements of the code and treated all creditors equitably. So equitably doesn't mean equally, right? A dissenting financial creditor cannot defeat a plan that complies with section 30 subsection 2. Now, what are the requirements of section 30 subsection 2? Any idea? What
Sir,
section 30 subsection 2 says?
the dissenting financial creditors shall get at least the liquidation value,
Right.
and the operational creditor should get at least the liquidation value or the
Fair value.
from the plan, the resolution plan, the value from the resolution plan,
And
whichever
has
is
been,
higher.
right, and has been approved by the requisite majority of the COC merely by asserting comparatively unfavorable treatment. The standard is equitable, not identical treatment. ठीक है, तो वो ये कहता है कि इक्विटेबल होना चाहिए, जरूरी नहीं इक्वल हो. नाउ ऑन यमुना एक्सप्रेसवेज, on Yamuna Expressway concerns regarding land allocations and dues, NCLT addressed them so as to ensure that the resolution plan complied with regulatory requirements and protected the interest of all stakeholders, including the statutory authority. तो इसमें ये था बेसिकली कि ये जो जेपी इंफ्राटेक अप्रूवल, इट इलस्ट्रेट्स द एप्लीकेशन ऑफ द इक्विटेबल ट्रीटमेंट. तो यहाँ कॉन्सेप्ट क्या आया? इक्विटेबल. इक्विटेबल और इक्वल में फर्क है, ठीक है. And commercial wisdom principles at the approval stage. A dissenting financial creditor's objection does not defeat a compliant plan, and statutory authority concerns are addressed within the plan. कुछ क्वेश्चंस देखते हैं क्या बोलते हैं. In JP Infratech, ICICI Bank as a dissenting financial creditor challenged the Suraksha Realty Resolution Plan. NCLT ने क्या किया इसमें?
डिसमिस किया था. So
हाँ.
B point.
Oh,
dismiss.
Right. Because they said that the plan meets the requirement of section 30 subsection 2 and it treats all the creditors equitably. In JP Infratech, home buyers were recognized as
Financial creditors.
So
Financial
pivotal
creditors.
precedent granting them COC representation. Okay. Next case law. Inquest Fintech Private Limited versus Maya Gupta. So इसमें इशू क्या था? ये केस है ना सिलेबस में काजल किरण जी?
Yes, sir.
ये सिलेबस में है ना केस?
Inquest in Fintech Private Limited. एक
हाँ.
मिनट सर.
है?
Yes, sir, है
ना? तो MS Kumar ji, can you read this case or can you explain it? What is this case?
Yeah.
You can read it from here also, no issues.
Yeah, I'm reading that. So NCLT 5, Inquest Fintech Private Limited versus Ms. Maya Gupta, liquidator of Rain Automotive India Private Limited. IA 35, 36 and 57 for 2022. CP number IB 1095 ND 2019 NCLT. It deals with the assignment of not readily realizable assets. Under Regulation 37A of the Liquidation Process Regulations, the timing of assignment post-adjudication, who may pursue avoidance applications under sections 43, 45, 50, 66.
So what is this concept of not readily realizable assets? Anyone? ये क्या होते हैं not readily realizable assets?
उसमें कुछ लिटिगेशन या कुछ इश्यूज हो सकता है सर.
हाँ.
तो जैसे
नहीं, कोई
घर है,
एग्जांपल दे
बना
सकते
नहीं
हैं
है.
आप? कोई
जैसे
एग्जांपल दे
सर
सकते हैं?
जैसे सर कोई घर है जो रेडी नहीं है अभी हमारे पास, अंडर कंस्ट्रक्शन है.
नहीं.
एक टर्म आएगा सर, एक टर्म आएगा.
Or is it a debt assets?
इसमें डेटर्स आएंगे बेसिकली. डेटर्स, अमाउंट्स रिसीवेबल. मान लो आपने किसी पार्टी से पैसे लेने हैं, ठीक है, और वो जो है वो रिकवरेबल नहीं है, उसमें कोई लिटिगेशन चल रहा है. ये एक एग्जांपल हो सकता है. The other examples could be that suppose some under construction property is there, not readily realizable, which cannot be sold despite auction. आपने auction भी कर लिया, try कर लिया, so they are not easily saleable. So such assets are called not readily realizable assets. They could be peculiar for the organization which doesn't have much value for the outside world. ठीक है, तो not NRRA इनको कहते हैं, not readily realizable assets. So in the liquidation of this Rain Automotive India Private Limited, the liquidator sought to deal with not readily realizable assets. ये रेगुलेशन 37 है, आपके सिलेबस में है ना?
रेगुलेशन 37, ये सर।
हाँ, है या नहीं?
यस सर।
है। क्या बोलता है 37 है? एमवीएस कुमार जी,
Hmm.
what does 37 a says? If you have got a book also, book या कुछ भी soft copy, anyone?
Yes, yes, I am taking.
हाँ,
Sir, it talks about resolution plan.
हम्म।
Actually, 37 only is there. 37A is not there.
हम्म। हाँ, 37 में भी तो न्यू एडिशन, ये जो आईबीसी कोड नया आया ना, उसमें एडिशन होगा ऐसा मुझे लग रहा है
Yeah.
ना?
37 is a resolution plan. That's what.
हम्म।
I think it is not in our syllabus, no? You don't need to read, right?
हाँ, ऐसा ही लग रहा है कुछ। हाँ। नहीं, ये केस लॉ तो हमारे सिलेबस में है कि नहीं है? दिस दिस केस लॉ इज इट इन अवर सिलेबस और नॉट? मेरा क्वेश्चन ये है।
I don't think so. One second.
Yes, sir. Inquest fintech is in our syllabus.
है ना? हाँ। तो ऑल्दो दिस
सर
37
ये
ए माइट हैव कम
37 ये भी
लेटर।
है सर, ये 37 है जो है वो लिक्विडेशन रेगुलेशंस पे है सर।
हाँ,
Liquidator may not assign or transfer a not readily realizable asset through a transparent process in consultation with the stakeholders, consultation committee in accordance with the regulation 31A for a consideration to any person who is eligible to submit a resolution plan for insolvency resolution of the corporate debtor.
बट वरुण रमन जी, when this regulation 37 ए came, what is the date of enforcement of this
सर ये
regulation?
जो मैं रेगुलेशंस देख रहा हूँ सर, वो जो हमारा सिलेबस के लिए अप्लीकेबल है वही देख रहा हूँ सर मैंने।
अच्छा, ठीक है। हाँ, तो 37 ए है इसका मतलब।
ये लिक्विडेशन रेगुलेशन है सर।
हाँ, लिक्विडेशन, यस यस, हाँ।
हाँ सर। हाँ सर।
हाँ, लिक्विडेशन ही है, तो लिक्विडेशन रेगुलेशन।
हाँ सर।
So NCLT held that although Regulation 37A of the Liquidation Process Regulations permits the assignment of NRRAs, ठीक है भाई, होता क्या है? पहली बात, whether you can assign the not readily realizable assets, this is one thing, ठीक है? So they said that Regulation 37A allows that okay, you can assign not readily realizable assets also. Assignment का concept क्या है? Can you explain the concept of assignment? Assignment क्या होता है भाई? सपोज ए
सर
पार्टी
ये
हैज
जो
गॉट एन
एसेट
डेट
है
टू
उसके
रिकवर।
उसके साथ जो भी लाइबिलिटी है दोनों को लेकर के असाइन कर देते हैं सर किसी को।
हाँ, बेसिकली क्या होता है कि सपोज एनी डेट इज देयर, सो यू
या
कैन असाइन इट एनी टाइम बाय वे ऑफ
यस
एन
सर।
असाइनमेंट एग्रीमेंट, है ना?
यस सर।
असाइनर असाइनी वाला कॉन्सेप्ट है ना, असाइनमेंट ऑफ डेट्स।
यस। यस सर।
सो सच ये बोलता है एनसीएलटी हेल्ड दैट ऑल्दो रेगुलेशन 37A परमिट्स द असाइनमेंट ऑफ एनआरआरस, सच असाइनमेंट शुड अकर पोस्ट एडजुडिकेशन, ठीक है? दैट इज वंस द claims have been crystallized by the adjudicating authority. Assigning claims before adjudication, while still uncertain, could lead to undervaluation and potential loss to stakeholders. So, tribunal emphasized that avoidance applications under these sections are to be filed and pursued by the RP or the liquidator. An assignee does not have statutory authority to substitute the liquidator in these applications. So, another question which came, that whether the assignee can pursue these applications, the answer is no. Only the RP or liquidator can pursue these applications. Where such claims are sold at a negligible value before adjudication, the transaction itself could be suspect. Hence, the insistence on crystallization before assignment to protect shareholders' value. So, NCLT accordingly regulated the timing and manner of assignment of NRRs. तो NCLT ने क्या किया? एनसीएलटी ने बोला कि भाई टाइमिंग और मैनर दिस इज इंपॉर्टेंट सो एज टू प्रोटेक्ट वैल्यू एंड प्रिजर्व द स्टैट्यूटरी रोल ऑफ द लिक्विडेटर इन अवॉइडेंस प्रोसीडिंग्स. ठीक है. So Inquest FinTech clarifies that NRRAs, including avoidance claims, should be assigned only post adjudication under Regulation 37A to avoid undervaluation. भाई कोई PUFE ट्रांजेक्शन भी है, ठीक है, और वहां पर NRRAs भी है, तो जब ये इसकी अवॉइडेंस एप्लीकेशन पेंडिंग है तो क्या उस टाइम पे वो असाइन हो सकते हैं? द आंसर इज नो. वो ये कह रहा है कि अगर कोई नॉट रेडिली रियलाइजेबल एसेट है, ठीक है, कोई भी एसेट है विच यू कैन नॉट सेल, ठीक है, और उसकी PUFE एप्लीकेशन भी लगी हुई है उसी एसेट के बारे में, तो उसके बीच में आप असाइन कर सकते हो या नहीं कर सकते? दिस इज द क्वेश्चन. तो एनसीएलटी ने बोला कि अगर NRRA कोई एसेट है और उसका PUFE एप्लीकेशन भी फाइल्ड है तो पहले PUFE एप्लीकेशन का डिसीजन होने दीजिए, उसके बाद आप असाइन कर सकते हो. ये बोला मोटा मोटा इसमें, ठीक है. एंड दैट अवॉइडेंस एप्लीकेशंस मस्ट बी परसूड बाय द आरपी और लिक्विडेटर. जो असाइनी है ही कैन नॉट सब्स्टिट्यूट कर, ठीक है. तो इन इंक्वेस्ट फिनटेक वर्सेस माया गुप्ता लिक्विडेटर रिगार्डिंग असाइनमेंट ऑफ नॉट रेडिली रियलाइजेबल एसेट्स, क्या आंसर होना चाहिए?
Sir, D.
D should be the answer. Assignment of NRRAs should occur post adjudication and assignee has no locus standi to pursue avoidance applications. Only RP or liquidator can do so. Next question है, under regulation 37A of IBBI liquidation process regulations, assignment of NRRAs should occur कब होना चाहिए?
तो post adjudication when claims are
हाँ,
crystallized.
ठीक है. In Inquest FinTech versus Maya Gupta, NRRAs were assigned for ₹50,000. भाई क्लेम की वैल्यू इतनी थी और उसको 50,000 रुपए पर असाइन कर दिया, तो क्लेम्स की वैल्यू कितनी थी ये बताना है आपको. आंसर में देख सकते हैं, पीछे से देख कर बता सकते हैं कितनी वैल्यू के डेट थे. 542 का आंसर देख लीजिए, लास्ट में दे रखे आंसर. अभी शेयर किया ना मैंने व्हाट्सएप पे. वरुण रमन जी आप बताइए.
तो C है 26.38 crore.
तो इतने के वैल्यू के जो डेट थे वो 50,000 में असाइन करती, तो इसका मतलब गड़बड़ है ना कुछ.
हाँ सर.
Yes sir. कुछ ज्यादा ही अंडरवैल्यूड हो गया सर.
परवीन आर नवानदार RP ऑफ VOVL लिमिटेड वर्सेस BPRL वेंचर्स, ठीक है. अब इसमें क्या है कि एक राइट ऑफ फर्स्ट रिफ्यूजल होता है. सो एक्सरसाइज ऑफ राइट ऑफ फर्स्ट रिफ्यूजल टू एक्वायर द कॉर्पोरेट डेटर स्टेक, approval of a transaction with an equity partner, constitution of a monitoring committee, liquidation of residual assets under section 33(1)(a. So these were the points which were covered in this case. ठीक है, एक बार पढ़ लीजिए. MBS कुमार जी, कैन यू रीड इट? क्या फैक्ट्स थे?
Yes. In the CIRP of VOVL Limited, the corporate debtor, BPRL exercises its right of first refusal to acquire VOVL's 50% stake in IBB. The COC approved BPRL's offer at its 40th meeting on 2nd May 2023. The resolution professional filed an application seeking approval of transaction with BPRL and constitution of a monitoring committee to oversee its consummation. A competing objection by PRO-AC was also raised. Issues: whether the transaction with BPRL, its exercise of ROF to acquire the corporate debtor's stake should be approved and a monitoring committee constituted to oversee it. How the residual assets of corporate debtor to be dealt with. So the decision and reasoning ratio. NCLT allowed the transaction with the BPRL, giving effect to the BPRL's exercise of its right of first refusal to acquire POVL's 50% stake in IBV, as approved by the Committee of Creditors. The objection by Prio SA was dismissed. A monitoring committee comprising representatives from SBI, IDBI, Bank, and Exim was constituted to oversee consummation of transaction, ensuring proper implementation and protection of shareholders' interest. The NCLT permitted the liquidation of VOVL's residual assets under Section 33(1)A of the Code, appointing Mr. Praveen R. Navandar as a liquidator to deal with those assets after the stake sale. The decision thus gives the effect to a contractual ROFR within the insolvency process, approved a value realizing sale of stake in equity partner, and provided for orderly liquidation of the remaining assets. The significance is Praveen R. Navandar illustrates the accommodation of contractual rights of first refusal within the insolvency process. The sale of corporate debtor's stake to an equity partner exercising ROFR right of refusal overseen by a monitoring committee with residual assets liquidated under Section 33(1)A. It is a useful example of value realization and the interplay of the contractual rights with the code. Likely questions: treatment of a ROFR and the role of a monitoring committee.
एक्चुअली क्या है, वो ये कह रहा है इस केस में कि अगर किसी कंपनी के पास दूसरे की इक्विटी है, ठीक है, और आपने वो चीज बेचनी है, ये कॉन्सेप्ट ट्रांसफर ऑफ प्रॉपर्टी एक्ट में भी है। ट्रांसफर ऑफ प्रॉपर्टी एक्ट में क्या कॉन्सेप्ट है? राइट ऑफ प्रीएम्पशन है। व्हाट इज दैट राइट ऑफ प्रीएम्पशन? किसी को आइडिया है क्या राइट ऑफ प्रीएम्पशन क्या होता है? ट्रांसफर ऑफ प्रॉपर्टी आपके सिलेबस में है मेरे हिसाब से, है ना? है ना? तो राइट ऑफ प्रीएम्पशन में क्या होता है? सपोज आई विल गिव यू एन एग्जांपल। सपोज देयर आर टू ब्रदर्स लिविंग इन अ हाउस, राइट? नाउ दे वांट टू सेल द हाउस। वन इज इंटरेस्टेड इन सेलिंग, द अदर इज नॉट इंटरेस्टेड इन सेलिंग। So the first priority will be given to the person who is not interested in selling the house. लॉ क्या बोलता है कि भाई अगर आपने बाहर वाले को बेचना है तो आप उसको बेच दो। ये होता है राइट ऑफ प्रीएम्पशन। यहां पर क्या है? राइट ऑफ फर्स्ट रिफ्यूजल। राइट ऑफ फर्स्ट रिफ्यूजल क्या है कि भाई आपके पास इक्विटी है, दो इक्विटी पार्टनर्स हैं, ठीक है, तो वो ये कह रहा है कि भाई आपको अगर एक उसमें कोई डाइवेस्टमेंट करनी है एसेट्स में, तो राइट ऑफ फर्स्ट रिफ्यूजल। राइट ऑफ फर्स्ट रिफ्यूजल मतलब आप इक्विटी पार्टनर्स को दीजिए। दिस इज द क्वेश्चन बेसिकली यहां पर। सो इट इज द एकोमोडेशन ऑफ अ कॉन्ट्रेक्चुअल राइट ऑफ फर्स्ट रिफ्यूजल। अगर वो इंटरेस्टेड नहीं है तो फिर दूसरे को बेचो आप। ये है इसमें स्टोरी। सो इफ देयर इज ए इक्विटी पार्टनर, बिकॉज ही इज ऑलरेडी इन नो ऑफ द बिजनेस, उसको तो बिजनेस के बारे में पता है ऑलरेडी। So COC approved BPRL exercising its right of first refusal to acquire VOVL's 50% stake in IBV. तो NCLT ने क्या कहा? NCLT allowed the transaction, constituted a monitoring committee, also permitted liquidation of VOVL's residual assets under section 33(1)A. अच्छा, ये जो मॉनिटरिंग कमेटी थी इसमें कौन कौन से रिप्रेजेंटेटिव थे? किसके थे रिप्रेजेंटेटिव? ये आप देख सकते हो, आंसर में देख सकते हो। सवाल कहीं से भी पूछ लेगा वो एग्जाम में। क्यों काजल किरण जी, क्या आंसर है इसका?
B for SBI, IDBI Bank and Exim Bank.
हाँ, अच्छा ये हो गया। अब एनसीएलटी पर चलते हैं। ये इतने ही थे मेरे ख्याल ना, 5 ही थे इसमें। कितने केस है? 6 ही केस है ना एनसीएलटी में। अब एनसीएलटी वाला देखते हैं। एनसीएलटी के में मेरे ख्याल थोड़ी 8 है शायद। एनसीएलटी वाले कर लेते।
सर NCLAT में 13 केसेस है।
13 है? ठीक है,
Yes,
जो भी
sir.
है। वर्सन्ना इस्पात, ठीक है। बरसाना इस्पात का क्या केस है? एमवीएस कुमार, ये प्लीज रीड दिस केस. क्या केस है ये?
It deals with whether Section 14 of the code overrides the PMLA. Whether ED attachments made before the moratorium can be released under Section 14, the distinct field of proceeds of crime. So,
थोड़ा
facts.
सा प्लीज रीड अ बिट लाउडर, थोड़ा सा हल्का सा. Facts.
Facts. The Directorate of Enforcement had attached the certain properties of Varsana Ispat Limited, the corporate debtor, under Prevention of Money Laundering Act 2002 PMLA. The attachment order was issued on 10 July 2017, prior to the declaration of moratorium in the corporate debtor CARP. The resolution professional applied to the NCLT Kolkata to release the attached assets, arguing that Section 14 of the Code moratorium had an overriding effect via Section 238, that no authority could disrupt the CARP. The NCLT declined, and the matter came before NCLAT. Issues: whether an order of attachment by the ED is maintainable during the moratorium, whether Section 14 of the Code applies to criminal proceedings or actions concerning proceeds of crime, whether PMLA overrides or is overridden by the Code in this context. So, the decisions and reasoning ratios. The NCLAT held that Section 14 of the Code does not override the PMLA in cases of money laundering. PMLA relates to the proceeds of crime, and the offense of money laundering resulting in confiscation of property derived from or involved in money laundering. Section 14 of the Code, which is directed at preserving the corporate debtor's estate in insolvency, is not applicable to such proceedings. Because the attachment by the ED was made much prior to the moratorium and concerned proceeds of crime, the corporate debtor could not derive any advantage from Section 14 to secure the release of attached assets. The offense of money laundering is punishable with rigorous imprisonment, does not override the PMLA, and the assets attached by the ED, especially pre-moratorium as proceeds of crime, cannot be released under Section 14. It aligns Rajiv Chakravarti, Delhi High Court. Can you scroll? No.
Just a
Up.
minute.
And should be contrasted with the post-plan position under Section 32A in Shiv Charan. Likely question: does Section 14 override PMLA? Answer is no. So,
Please read the questions also.
In Varsana, Ispat was a deputy director of enforcement NCLAT. The tribunal held that Section 14 moratorium does not override C. Does not override PMLA. Does Section
So it
14
says
of
it's a criminal law. PMLA is a criminal law. So basically, IBC is concerned with maximization of value. So it doesn't protect criminal actions. Yes.
Does Section 14 of the Code override PMLA in money laundering cases?
No.
No.
Next question.
In Varsana, Ispat was as deputy director enforcement. The distinction between IBC and PMLA was drawn on the basis that PMLA deals with proceeds of crime. Okay. The PMLA concerns proceeds of the crime and money.
Proceeds of crime and offense, yes.
ED's attachment here was made
much prior to the
much prior to the moratorium.
Moratorium. Yes.
And next question: the code and the PMLA operate
in conflict with the PMLA.
In different fields and may proceed
simultaneously. Point
right.
A, sir.
Right. So A should be the answer. So ex-directors and shareholders can claim Section 14 protection against PMLA action. Yeah. क्या आंसर होगा?
No.
ठीक. Varsana Ispat aligns with the High Court order. Decision in
Rajiv Chakravarti.
Right. So Kundan Care Products versus Amit Gupta. So here the issue is whether a successful resolution applicant may withdraw an approved resolution plan, the binding contractual nature of an approved plan, estoppel by conduct. So if the COC has approved the plan, right, and it is pending with the adjudicating authority. Now at this stage, whether the successful resolution applicant can be allowed to withdraw the resolution plan, this is the issue in this case.
No,
And
sir.
same issue came in some other cases also, like ABIC Singapore and all, because of the pandemic period. Because sometimes adjudicating authorities also take much time, say 2 years, 3 years for approval of the resolution plan. And the successful resolution applicant says that my dynamics has changed now, right? So when I put up the plan, it was considering the economics prevailing at that stage. But now the situation has changed because the adjudicating authority has taken so much time. So I may be allowed to withdraw. So the issue here is whether you can withdraw. The answer is no. पढ़ लीजिए एक बार केवीएस कुमार जी. फैक्ट्स क्या है फैक्ट्स?
Kundan Care Products Limited, the successful resolution applicant applied to withdraw its resolution plan and to have its performance plan guarantee returned, contending that the approved plan had become commercially unviable owing to delay in concluding the CIRP. The application was rejected, and the successful resolution applicant appealed to the NCLAT, arguing that there was no legal basis for holding that a post-approval withdrawal application was not maintainable. Issues: whether after the approval of the resolution plan by the Committee of Creditors, the adjudicating authority has jurisdiction to entertain or permit the withdrawal application filed by the resolution applicant. The decision and reasoning. The NCLAT held that once a resolution plan is approved by a Committee of Creditors, it becomes a binding contract between the parties, and the successful resolution applicant cannot be permitted to withdraw it. Withdrawal would have the effect of pushing the corporate debtor into liquidation. There is no provision in the code entitling successful resolution applicant to seek withdrawal after its plan had been approved by the requisite majority of the Committee of Creditors. The approved plan incorporates contractual terms binding on the applicant. It is not a contract of personal service that would be legally unenforceable. Therefore, the applicant is stopped by its conduct from wriggling out of the liabilities incurred under the approved plan. Permitting a walkout would leave the stakeholders devastated as the corporate debtor's assets values depletes the passage of time consumed in this year. So therefore, the appeal is dismissed, and the successful resolution applicant held bound by a approved plan.
क्वेश्चंस देख लेते हैं एक बारी. क्वेश्चन क्या है?
In the Kundan Care Products was Amit NCLAT. Once a resolution plan is approved by the Committee of Creditors, successful resolution can. Yeah.
Next question.
Can a successful resolution applicant withdraw its plan after the Committee of? No. No. An approved resolution plan is treated as a binding contract between the parties. Withdrawal by the SRA successful resolution applicant would have the effect of
pushing the corporate debtor into liquidation.
B should be the answer.
Successful resolution applicant is prevented from resigning by moratorium.
Estoppel by conduct.
Estoppel by conduct. D should be the answer. Yes.
Is there any provision in the code permitting post-approval withdrawal by SRA?
No.
Kundan Care is the NCLAT counterpart to?
ABIC Singapore.
ABIC Singapore. Yes. Ramesh Kimal versus Siemens Gamesa Renewable Power Private Limited. एक बार पढ़ लीजिए क्या केस है. Please read this.
It deals with Section 10A, bar on initiation of CIRP for defaults arising on or after 25 March 2020. The distinction between the initiation date and the commencement date, the retrospective effect of Section 10A bar.
अच्छा, anyone having a copy of the Bear Code? Can you read Section 10A? Section 10A बहुत छोटा सा section है. Can you read it? सेक्शन 10A क्या बोलता है? सेक्शन 10A कुछ बोलता है ना, बहुत छोटा सा सेक्शन है, जरा सा सेक्शन है, 2-3 लाइन का। वरुण रमन जी और एनीबडी?
सर खोल रहा हूँ सर, एक मिनट।
यस। हाँ।
Sir, suspension of intimation of CIRP process. तो वो जो कोविड के टाइम पे अपना
हाँ
कूलिंग पीरियड दिया गया था
हाँ
उसके
हाँ
लिए।
हाँ, एक बार बेयर टेक्स्ट पढ़ लीजिए कोड का, कोड से पढ़िए। कोड होना चाहिए आपके सामने, बेयर टेक्स्ट पढ़ना है।
So, suspension of initiation of corporate insolvency resolution process,
हाँ देखिए,
notwithstanding
एक
anything.
इंपॉर्टेंट बात क्या है? इनिशिएशन, है ना? सस्पेंशन ऑफ इनिशिएशन बोल रहा है। चलिए पढ़िए।
Notwithstanding anything contained in section 7, 9 and 10, no application for initiation of corporate insolvency resolution process of a corporate debtor itself shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf, provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. For the removal of doubts, it is hereby clarified that the provisions of this section shall not apply to any default committed under these said sections before 25th March 2020.
मतलब ये, अच्छा, ये जो कोविड पीरियड था, उस पीरियड में भी एनसीएलटी में एप्लीकेशन फाइल हो रही थी या नहीं हो रही थी? पहले तो ये बताइए, कोविड पीरियड में क्या हो रहा था?
सर हो रही थी क्योंकि ये नोटिफिकेशन बाद में आया था।
हाँ, नहीं बात, वो तो बात ठीक है, वो तो 5
सर
जून को आया था ये।
ऑनलाइन हो रही थी, ऑनलाइन चल रहा था,
और हाँ,
ऑनलाइन।
और उसके अलावा ये है, इसमें टेने में खुद भी लिखा है, क्या टेने में लिखा है? टेने में लिखा है, मान लीजिए डिफॉल्ट आपका 19 में हो गया, 2019 में, तो फिर इसमें कोई बार नहीं है यहाँ एप्लीकेशन, क्योंकि अपना लिमिटेशन पीरियड तो चल ही रहा है ना उसका। लिमिटेशन पीरियड के बारे में जो क्लैरिफिकेशन आया बाद में आया, अगर मान लीजिए डिफॉल्ट 19 में हो गया तो 20 में भी एप्लीकेशन फाइल कर सकते हो आप। ऐसा नहीं है कि आप एप्लीकेशन फाइल नहीं कर सकते, ठीक है?
वो डिफॉल्ट पीरियड देखना
हाँ,
पड़ेगा कि
डिफॉल्ट
डिफॉल्ट
पीरियड देखना है आपको। डिफॉल्ट कब अराइज होना चाहिए? ऑन और आफ्टर 25th,
25 मार्च
क्योंकि
2020।
उन्होंने लिख भी दिया ना नीचे, अभी पढ़ा ना काजल किरण जी ने, क्या लास्ट लाइन पढ़ी एक बारी? प्रोवाइडेड, जो प्रोवाइजो
Yes,
लिखा
sir.
है,
Provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the
नहीं
said
इससे
period.
इससे अगली लाइन, इससे अगली लाइन।
इसके लास्ट वाली
हाँ
एक्सप्लेनेशन था जो।
For the removal of doubts,
हाँ
it is hereby clarified that the provisions of the section shall not apply to any default committed under these said sections before 25th March 2020.
यस सर।
हाँ, तो अगर बिफोर 25 मार्च को ही हुआ डिफॉल्ट तो ये सेक्शन अप्लाई नहीं होगा, उसके लिए एप्लीकेशन फाइल हो सकती है। और यहाँ पर इंपॉर्टेंट क्या है? इनिशिएशन डेट और कमेंसमेंट डेट नहीं है, ठीक है? इनिशिएशन डेट, इनिशिएशन डेट क्या होती है? डेट ऑफ फाइलिंग ऑफ द एप्लीकेशन। दोनों में फर्क है ना, कमेंसमेंट डेट होती है ये जहां पर सीआईआरपी कमेंस हो जाती है।
Admission.
हाँ, so here the appellant and operational creditor filed an application on 11th May, ठीक है, in respect of a default said to have occurred on 30th April। तो यहाँ पर डिफॉल्ट कब हुआ था? 30th of April को। Subsequently, section 10A was inserted by the IBC Amendment Ordinance 2020 and it was published on 5th of June 2020 with retrospective effect, ठीक है? 25 मार्च को नहीं आया था, ये आया था 5 जून को, ठीक है
यस
ना?
सर।
बट लेकिन उसमें रिट्रोस्पेक्टिव इफेक्ट दिखाया फ्रॉम 25th मार्च। So section 10A provides that notwithstanding section 7, 9 and 10, no application for initiation of CIRP shall be filed for any default arising on or after 25th March for a specified period. So the question was whether the appellant's application in respect of a 30th April 2020 default was barred.
Sir, scroll करिए ना please.
हाँ, तो क्वेश्चन ये था, यहां पर डिफॉल्ट कब हुआ है? ऑन और आफ्टर 25 मार्च, 30 अप्रैल को हुआ है, ठीक है ना? तो whether an application in respect of a default committed on or after 25th March filed before the ordinance came into force on 5th June is maintainable in view of the bar in section 10A. इन्होंने बोला भाई देखो ऑर्डिनेंस तो बाद में आया, तो क्या ये एप्लीकेशन मेंटेनेबल है या नहीं? एनसीएलटी ने क्या कहा? एनसीएलटी ने कहा कि इनिशिएशन डेट व्हेन द क्रेडिटर फाइल्स इज डिफरेंट फ्रॉम द कमेंसमेंट डेट व्हेन सीआईआरपी इज एडमिटेड. So section 10A bars the filing of an application for any default arising on or after 25th March. And this bar applies irrespective of when the application was filed. ठीक है? The appellant had specified 30th April as the date of default. ठीक है? And this date falls squarely after the 25th March cutoff date. So the default therefore attracted the section 10A bar. तो section 10A से hit हो जाएगा ये. Because section 10A operates retrospectively from 25th March and its explanation clarifies that it does not apply to defaults committed before that date, an application in respect of a post cutoff default cannot be entertained even if it was filed before the ordinance promulgation. The adjudicating authority was therefore justified in rejecting the section 9 application. Appeal was dismissed. So this is a leading authority on section 10A. The bar attaches to the date of default. Date of default देखनी है आपको. Date of default क्या है? On or after 25th March, not the date of filing, and it applies retrospectively. ठीक है? So applications for COVID period defaults are barred even if filed before the ordinance. Note the initiation date versus commencement date distinction. In Ramesh Kimal versus Siemens Gamesha, section 10A case NCLT, it was clarified that क्या आंसर होना चाहिए? So initiation date is different from the commencement date of CIRP. Section 10A bars initiation of CIRP, not commencement.
Commencement, yes, sir.
Section 10A bars the filing of a CIRP application for any default arising
On or after
On or
25th
after
March.
25th March 2020.
Section 10A of IBC was introduced to suspend filing of insolvency applications. It is triggered by
Default occurring on or after 25th.
Default occurring on or after 25th March.
C.
the section 10A bar depends on
Date of filing.
The date of filing.
Date of default.
नहीं
Date
नहीं
of default.
हाँ bar yeah date of default sir.
हाँ.
Date of
Date of
default.
Section 10A of IBC was enacted in response to
Economic disruption caused by
right.
COVID.
D. Yes, sir.
The initiation date and the commencement date are
Different.
Different filing versus admission.
now. In Ramesh Kibal versus Siemens Gamesha, section 10A bars
The initiation of CIRP, but the initiation date and date.
Sir और
तो
scroll कर.
हाँ
No.
ये
A
चारों
हो.
नजर आ रहे. हाँ A से मिल गया.
A will be the answer. A.
Section 10A operates
Retrospectively
A.
from 21st March 2020.
an application for a post cutoff default filed before the ordinance is
Maintainable.
Barred by section 10A.
default committed before 25th March are
Not affected by section 10A.
यूनियन ऑफ इंडिया वर्सेस विजय कुमार वी अय्यर. एक बार पढ़ लीजिए. कादर किरण जी आप पढ़िए. क्या केस है?
Yes, sir. Yes, sir. Whether spectrum is an asset of the corporate debtor capable of insolvency proceedings. The nature of a spectrum license, whether date of time dues are operational dues, whether spectrum
DOT मतलब डिपार्टमेंट ऑफ टेलीकॉम.
Okay, Department of Telecom dues are operational dues, whether spectrum can be treated as a security interest.
Hmm.
Facts. The appeals concern telecom companies, corporate debtors holding spectrum under licenses granted by the Department of Telecommunications. The question arose whether spectrum held under a license from the government is an asset of the corporate debtor that can be dealt with in insolvency, and how the uh, Department of Telecommunications dues rank. The government contended that ownership and control of spectrum always vests in the Union of India and never in the licenses, who have only a right to use. The licensees, on the other hand, sought to treat the right to use spectrum as an asset available for the CIRP. Issues. Whether the right to use spectrum is an asset of the corporator that can be subjected to insolvency proceedings, whether dues of the central government and or duty under the license are operational dues, whether spectrum can be treated as a security interest, and the effect on lenders. Decision and reasoning. The NCLAT summarized its conclusion: spectrum is a natural resource and the government holds it as cestui que trust, a trustee for the people. The right to use spectrum is an intangible asset of the licensee, telecom company, corporate debtor, and can be subjected to insolvency or liquidation proceedings. The dues of the central government or DOT under the license, including deferred or default payment installments of spectrum acquisition cost, fall within the ambit of operational dues under the code, payable primarily in terms of the license agreement. Spectrum cannot be treated as a security interest by lenders, given that tripartite arrangement according to first charge or priority to the DOT and the DOT's power to suspend, revoke, or terminate the license and to levy fines under Section 220 of the Indian Telegraph Act. Any security interest of the lenders would be fragile and vulnerable, so its enforcement need not even be considered. The NCLAT also cautioned the triggering CIRP with the object of wiping off spectrum dues, not for genuine insolvency resolution, but with malicious or fraudulent intent, would be impermissible, and a natural resource is not available for use without payment of the requisite dues. Significance. Union of India versus Vijay Kumar Iyer holds that the right to use spectrum is an intangible asset that can be part of insolvency proceedings. That DOT or government does dues are operational dues, and that spectrum cannot be a security interest fee or for lenders. It connects with the Aircel NCLT decision on non-termination of spectrum licenses during moratorium. Likely questions are: duty dues operational? Yes. And can spectrum be a security interest? No. In Union of India versus Vijay Kumar Iyer NCLAT spectrum case, telecom spectrum was held to be
It's a D.
Sir, D will be the answer. An intangible asset of the telecom license that can be subject to insolvency or liquidation proceedings. The right to use spectrum is an intangible asset of the corporate debtor capable of insolvency proceedings.
Next.
In Union of India versus Vijay Kumar Iyer NCLAT, telecom spectrum is an intangible asset of the license or CD that can be subjected to insolvency or liquidation proceedings. Spectrum does not. Dues of Government of India or Director of Telecommunications are operational dues. The government holds spectrum as a trustee for the people. The dues of the DOT or central government under the license are operational dues. Can spectrum be treated as a security interest by lenders? No. Any security interest of the lenders in spectrum would be fragile and vulnerable, triggering
हाँ
CIRP merely to wipe off spectrum dues was said to be impermissible if with malicious or fraudulent intent.
ठीक. नेक्स्ट देखिए, मोहन जेम्स एंड ज्वेल्स प्राइवेट लिमिटेड वर्सेस विजय वर्मा. पढ़ लीजिए एक बारी, क्या है केस.
Yes, sir. Whether a liquidator may sell the corporate debtor as a going concern under Regulation 32, closure versus dissolution under Section 54, the limits of the adjudicating authority in commenting on IBBI's regulation making. In the liquidation of the corporate debtor, the liquidator sold it as a going concern in an e-auction and applied for closure of the liquidation process under Regulation 45 subclause 3 subclause A of the IBBI liquidation process regulations 2016. The highest bid being about rupees 4.52 crore. The adjudicating authority dismissed the application questioning the interplay of the going concern sale regulations with Section 54. Whether the liquidator is authorized to sell the corporate debtor as a going concern under Regulation 32 of the liquidation process regulations, whether the adjudicating authority was correct in holding Regulation 39C and 32A 45 subclause 3 liquidation to be inconsistent with Section 54 of the Code. Decision and reasoning. The NCLAT held that liquidation should be the last resort, and even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. Regulation 32 with Regulations 32A and 45 subclause 3 inserted after ArcelorMittal and Swiss Ribbons specifically defines the process for sale of the corporate debtor or its business as a going concern. Dissolution of the company is to be seen only as a last resort. Every attempt should be made to revive it and continue it as a going concern. The code does not prevent closure of the liquidation process where the corporate debtor is sold as a going concern under Regulation 32 subclause E. Following a closure report under Regulation 45 subclause 3 subclause A, to hold that only dissolution is available would demolish the spirit of the code. The NCLT held that the adjudicating authority exceeded its jurisdiction in commenting on the power and function of framing regulations by the IBBI. The legality and propriety of a regulation or notification or rule cannot be examined by the NCLT or NCLAT. The tribunal can only ascertain whether the procedure under the code is followed. On the facts, since the application under Section 33 seeking liquidation was filed before Regulation 39C was inserted, only Regulation 32A needed to be followed, and the liquidator had rightly followed the procedure. The sale as a going concern and closure were upheld. Mohan Gems and Jewels confirms that a liquidator may sell the corporate debtor as a going concern, closure, not merely dissolution, and reiterates that the NCLT or NCLAT cannot sit in judgment on the wires of IBBI regulations of IBBI versus SBI. Likely questions. Can the CD be sold as a going concern in liquidation? Yes. And can the tribunal test a regulation? Now questions. In Mohan Gems and Jewels versus Vijay Verma, NCLAT, a liquidator is authorized to
B. Sell the corporate debtor as a going
sell the corporate debtor as a going concern under Regulation 32 of liquidation process regulations. Can a liquidator sell the corporate debtor as a going concern under regulation? Yes. In Mohan Gems and Jewels versus Vijay Verma, Regulations 32 of IBBI liquidation process regulations permit a liquidator to sell the corporate debtor as a going concern. Is dissolution the only outcome available in liquidation? No. The business may be sold as a going concern. Closure of the liquidation process, Regulation 45 subclause 3 subclause versus dissolution. Closure follows a going concern sale, dissolution ends the company. Can the NCLT or NCLAT examine the legality or propriety of an IBBI regulation? No. It can only check that the court's procedure was followed. The adjudicating authority was held to have exceeded its jurisdiction in commenting on IBBS regulation making.
Jet Aircraft Maintenance Engineers Welfare Association versus Ashish
Ashish.
Chacharia. Varun Ramanji, can you read this case?
Yes, sir.
Yes.
This case deals with sale of non-core assets during CRP for value maximization. The sacrosanct status of provident fund gratuity dues payable in full irrespective of resolution plan. Facts. The appellant, a registered trade union, represented aircraft maintenance engineers of Jet Airways, pursued claims in the CARP. During the process, the COC deliberated on raising interim finance and on excluding certain non-core assets, such as BKC building encumbered to STFC from estate to maximize value, and on the treatment of employee statutory dues. The union sought recognition and full payment of provident fund and gratuity dues. The matter traveled through NCLT, NCLAT, and ultimately the Supreme Court. Issues. Whether the non-core assets of the corporate debtor may be sold during the CARP for value maximization, whether statutory dues owed to employees, such as provident fund gratuity, must be paid in full irrespective of the resolution plan. Decision in reasoning. The NCLAT held that sale of non-core assets during CRP is permissible for value maximization, consistent with the object of preserving and enhancing the value of the corporate debtor's estate. On employees' dues, the NCLAT, later affirmed by the Supreme Court, held that statutory dues owed to employees, provident fund, and gratuity are sacrosanct and must be honored in full during insolvency proceedings. The successful resolution applicant was directed to pay the full amount of PF and gratuity dues, as these are excluded from the liquidation estate and cannot be compromised in a resolution plan. This reflects the principle, also in Sunil Kumar Jain, that PF, pension, and gratuity fall outside the estate under section 36(4) and enjoy protection regardless of the plan's provisions. The decision accordingly reinforced the protection of employees' statutory dues under the code. Significance. Jet Aircraft Maintenance Engineers establishes that PF and gratuity dues are sacrosanct and payable in full and cannot be scaled down by a resolution plan, while permitting sale of non-core assets for value maximization. It complements Sunil Kumar Jain and Anuj Bajpai, EPFO, on section 36(4). Likely question, can PF or gratuity be compromised in a plan? No. Multiple questions. In Jet Airways Maintenance Engineers Welfare Association with Ashish Chacharia, NCLAT, the tribunal held should be option B, sir, sale of non-core assets for value maximization. Statutory dues are sacrosanct and must be honored in full. May non-core asset be sold during CRP? Yes, for value maximization. Option D. In Jet Aircraft Engineers case, NCLAT statutory dues, including PF and gratuity, are must be option D, sir. Sacrosanct and must be honored in full. They cannot be compromised in the resolution. Provident fund and gratuity dues must be. Again, I think option D, sir. Honored in full during insolvency. Can PF and gratuity dues be compromised in a resolution plan? No. Option is B. Question 474. Yeah. PF, pension, gratuity are excluded from the liquidation estate under section 36(4). The successful resolution applicant was directed to pay the full amount of PF and gratuity dues. This decision complements option B, Sunil Kumar Jain and Anuj Bajpai.
Right.
Yes.
Next, ये पढ़ लीजिए एक बारी. Please read this case. Varun Raman.
Yes, sir. Yes, sir. NCLAT 7, State Bank of India versus Mahendra Kumar Jajodia. Whether a Section 95 application against a personal guarantor can be rejected merely because no CIRP or liquidation of the principal borrower or corporate debtor is pending. The appropriate forum for personal guarantor insolvency. Facts. SBI filed an application under Section 95 of the Code for initiation of the insolvency resolution process against Mahendra Kumar Jajodia, a personal guarantor to the corporate debtor, before the NCLT Kolkata. The NCLT dismissed the application on the ground that such an application must be filed before the adjudicating authority where the corporate debtor's registered office is located and that no CARP or liquidation of the principal borrower was pending there. Issues. Whether an application under Section 95 against a personal guarantor can be rejected merely because no CARP or liquidation proceedings of the principal borrower or corporate debtor is pending. And next, before which NCLT such an application against a personal guarantor may be filed. Decision. The NCLAT overturned the dismissal, holding that an application under Section 95(1) for initiating the insolvency resolution process against a personal guarantor cannot be rejected merely on the ground that no CRP or liquidation of the principal borrower or corporate debtor was pending before the NCLT. Personal guarantors are distinct from the corporate debtor, and proceedings against them under Part 3 of the Code can be filed independently. There is no requirement that CARP against the corporate debtor be pending first. The guarantor's liability under Section 128 of the Indian Contract Act is independent and coextensive. The application may be filed before NCLT having jurisdiction over the personal guarantor. The adjudicating authority for personal guarantor is the NCLT per the 2019 notification, and the proceeding need not be confined to the jurisdiction of the corporate debtor. The NCLT thus broadened the scope for financial creditors to initiate insolvency against personal guarantors independently. Significance. Mahendra Kumar Jajodia establishes that a Section 95 application against a personal guarantor is maintainable even without a pending CRP or liquidation of the corporate debtor and can be filed where the guarantor is amenable. It complements SBI versus Ramakrishna, Lakshmipat Surana, and Lalit Kumar Jain in the guarantor cluster. Likely question: is a pending CRP against the corporate debtor a precondition to proceeding against the personal guarantor? No. Multiple choice questions. In SBI versus Mahendra Kumar Jajodia, it was held that Section 95(1) application against the personal guarantor option D, sir, cannot be rejected merely because no CARP or liquidation of the principal borrower is made. Next question. Can a Section 95 application against a personal guarantor be rejected merely because no CARP of the principal borrower is pending? Answer is no. B. Next question. Section 128 of the Indian Contract Act, relevant in SBI versus Mahendra Kumar Jajodia, provides that the liability of a surety is coextensive with the principal debtor. Creditor can directly sue the guarantor. Option A. 480. Personal guarantors are for Part 3 purposes distinct from the corporate debtor. Option D. Next question. In SBI versus Mahendra Kumar Jajodia, the tribunal held that a Section 95(1) application against a personal guarantor can be maintained. Option A, sir, even if no CARP or liquidation proceedings are pending. Must a CARP against the corporate debtor be pending first? Option D, no proceedings against the guarantor can be filed independently. The guarantor's liability under Section 128 of the Contract Act. Again, option D. Yeah. The adjudicating authority for personal guarantor is the NCLT as per the 2019. Yeah. This decision sits with the guarantor cluster, including option A, sir, SBI versus Ramakrishna and Lalit Kumar.
SBI versus Ramakrishna and Lalit Kumar.
नेक्स्ट ये लास्ट केस करेंगे.
ठीक है सर.
टेक्नोलॉजी डेवलपमेंट बोर्ड वर्सेस मिस्टर
अनिल
अनिल
गोयल
गोयल एंड अदर्स. यस
मैं पढ़ूं सर?
आप पढ़िए.
ठीक है सर. Technology Development Board versus Anil Goyal and others. Whether interstate priorities, first charge versus second charge, among secured creditors survive relinquishment of security under Section 52, equal ranking under Section 53(1)(b)(2) after relinquishment. Facts. Following the failure of CARP of Gujarat Oleochem Limited, the company went into liquidation. The Technology Development Board, a financial creditor with a second charge and about 14.54% voting share, had its claim of rupees 24.78 crore admitted. The liquidator distributed the sale proceeds exclusively to the first charge holders, giving nothing to TDB, reasoning that TDB held only a second charge. TDB contended that once secured creditors relinquish their security to the liquidation estate, the priority of charge loses significance, and Section 53 mandates equal ranking among secured creditors. Issues. Whether inter se priorities, first charge versus second charge, among secured creditors continue to govern the distribution of liquidation proceeds after those creditors have relinquished their security interests. Decision. The NCLAT held that once secured creditors relinquish their security interests to the liquidation estate under Section 52, they rank equally under Section 53 1B2 for distribution of liquidation proceeds, regardless of any prior inter se priorities such as first charge or second charge. The priority of the charge loses its significance on relinquishment when the asset is surrendered to the common pool and the rights attached to it are given up. There is no question of a first charge holder claiming priority over a second charge holder. Section 53 does not provide for any further classification among secured creditors who have relinquished. The court's waterfall mechanism overrides contractual or inter se arrangements among the secured creditors once they opt to participate in the liquidation estate. The sale proceeds must be distributed equitably among all such secured creditors. The NCLAT accordingly directed the liquidator to redistribute the proceeds equally among the relinquishing secured creditors, including TDB. The Supreme Court later stayed the NCLAT's judgment, indicating ongoing deliberation, but the NCLAT's reasoning is the syllabus position. Technology Development Board holds that inter se priorities among secured creditors do not survive relinquishment under Section 53. All relinquishing secured creditors rank pari passu and waterfall overrides inter-creditor arrangements. It is a key. Section 53 authority alongside Moser Bear and Paschim note the Supreme Court stay. Likely question, does a first charge retain priority after relinquishment? Answer is no. Multiple choice questions in Technology Development Board versus Anil Goyal regarding priority charge, first charge versus second after relinquishing of security interest. Option B, priority loses significance upon relinquishment. Sale proceeds go into a common pool. Next question. After relinquishment under Section 52, do inter se priorities among secured creditors govern distribution? No. No. Next question. In Technology Development Board versus Anil Goyal, relinquishment of security interest means okay, I think the option D, secured distinction between the first and second charge loses significance. 489. Relinquishing secured creditors rank under 53 to B. Equally, pari passu. On relinquishment, the priority of charge, again option D, loses its significance. Does Section 53 allow further classification among relinquishing secured creditors? No. The waterfall mechanism, once creditors join the estate, option C, overrides contractual or inter se agreements.
Yes.
In relation to these NCLAT judgment, the Supreme Court, option D, stayed, indicating ongoing deliberation.
Okay. So I think we can stop here for the time being. So please go through these case laws on your own and then we can further deliberate on this. ठीक है?
ठीक है. Thank you.
अभी
Sir.
next class में आप